The first defense is simple. They claim nothing happened. That is a factual defense. Nothing happened. Very simple. And the idea that nothing happened means basically this defendant didn't do anything wrong, period. A simple defense. And by the way, Trump's lawyers began telegraphing that they will rely more heavily on these kind of factual defenses. And don't underestimate simplicity. It is an important tool and lens when you're dealing with a jury. In fact, Trump defense attorney Will Scharf said they'd be doing this on the eve of the trial. Trump's lawyers denying that Trump had any tryst with Stormy Daniels, and that means that whatever she might testify, even if, quote, salacious, they told the jury, it just does not matter. Now, the lawyers similarly deny that Trump took any actions to try to pay her at the time, and that he didn't lie about any payments that were made to her, whether on his behalf or by someone else. To support that, of course, they got to deny the DA's evidence that suggests Trump was involved. So, faced with the receipts, how do you do that? Well, there are answers to this. And if you hear people say, oh, it's open and shut, it's one-sided, it's all easy, that's probably not someone who's very versed in how these trials actually work. Because the defense attorney, Todd Blanche, did have a strategy for this, and it's important to take a look at what they're doing. He told the jury that, okay, if there are these papers and evidence, they still don't automatically implicate Trump because he had, quote, nothing to do with any of those 34 pieces of paper, except that he signed onto the checks in the White House while he was running the country. That's not a crime, he argued. So that is a denial that anything criminal happened. Now, these type of denials that I'm telling you are not the only options. The next defense they have, you've certainly heard about, and I want to be clear, you can also think of this as a factual defense because they argue if anything bad did happen, then Michael Cohen did it, not defendant Trump. If anything happened, Cohen did it. Now, here's how that defense works as a counterattack, because they said, quote, unbeknownst to Trump, in all the years that Cohen worked for him, Cohen was also a criminal. Now, notice that is a little different than just saying nothing happened. Because if nothing bad happened, you wouldn't have to blame anyone, right? It's like, are you saying nobody ate the cookies, or are you saying somebody else ate the cookies? And as soon as you start saying somebody else ate the cookies, you're kind of admitting the cookies are gone, right? So you don't have to call some other witness a criminal or go after all this tough talk unless your alternative factual defense is, okay, maybe something happened, but they did it, the other guy. Now, Trump's legal team has been at this one for a while, which is why I'm betting if you watch the news, this might be familiar to you, the idea that they want to go at Cohen. In fact, both Scharf, who I just showed you, and then Trump defense attorney Joe Tacopina, you may remember, was sitting at that same arraignment table when Trump first learned what it means to be a defendant. Well, he also made this defense. And then there's a third defense. We also heard that this week, although I think, from what I can tell, it's gotten a little less scrutiny. But after those factual denials, if anything happened, then the argument is, okay, it's still not against the law. This is a strictly legal defense. You see how the first two we stamped factual, just to keep it clear? That's all about whether the thing went down or who did it. This is legal. If anything happened, maybe it's not against the law. Now, this matters because, let me tell you something, a jury could agree with this, or one or two people on the jury could get confused by this. And it has an extra benefit as a legal argument. It is stronger to help overturn even a conviction on appeal. I'm not going to get into all the weeds on that. We'll come back to this. We have weeks together if you keep watching the trial, but I'll remind you, we'll get into it more later. It is easier to get a conviction overturned on a legal appeal than one of the factual ones. And every defendant, including this one, has the right to appeal. Now, Rachel emphasized this in MSNBC's coverage on the first night of opening arguments, that this point that I'm talking about now, this legal defense, was the exact flashpoint where we heard the lawyers clash the most with the spicy and passionate objections during the opening itself. Trump's defense lawyers claimed that whatever happened, even if the jury thinks Trump did some of the things they deny, they claim that would still legally not be a crime. Rachel read this out, and I'm going to read it out again for you because it was an interesting moment. They said, oh, Cohen paying Daniels $130K for her agreeing not to publicly spread false claims about Trump is not illegal, according to Trump's defense lawyer. Now, the lawyer there says the word false. But the claim is key because it's a legal defense for the jury, even if they think Daniels' claims were true. In other words, even if the jury says, well, I do think they had some history or tryst, but maybe it's okay to sign an NDA. Maybe that's not a crime. And that was the exact moment when the DA's team objected. And then Trump's lawyer had to try a different route and put it this way. An NDA signing is perfectly legal. You'll learn companies do that all the time. And the defense there is a legal defense. NDAs can be legal. NDAs also can be off base. So the idea is that Trump can be convicted for every part of a plot carried out by others, just as the defense can attack the idea that the catch and kill plot was itself an illegal campaign activity. Now, take a breath. Those are the three types of defenses. The reason this one matters is that without a second crime like these election law violations, there's no felony. If there's no felony, then there's no felony trial, and this whole thing kind of evaporates into a smaller misdemeanor case. Now, earlier tonight, we were talking to the former SDNY chief, David Kelly, and we talked about this exact law the DA is using that discusses whether you promote or prevent the election of a person to public office by unlawful means. So that could matter a lot, and it could matter on appeal if they lay the predicate, the foundation, to say, hey, we discussed this at trial, and we're discussing it on appeal. This doesn't seem like the right application of that law. Again, that's not them saying it didn't happen, and it's not them blaming Cohen. It's saying even if it happened and even if he did it, maybe that's not an election law violation. Now, we've heard this argument before, which is why we try to go to the source around here, because long before this week's opening arguments, Attorney Tacopina hammered this same attack on the election law in our interview. And while we had a back and forth, and I'll show you some of it, legally, this could potentially work. The DA is saying the money was under the table campaign spending. Then Trump lawyer Tacopina and his lawyers today have basically been arguing if Trump would pay that money irrespective of the campaign, if he paid other NDAs or if the Inquirer did this other times, then this supposed campaign law violation could evaporate. Trump's current lead defense lawyer built on that same idea we heard from Tacopina, and he went even larger this week, saying you could take all the talk about magazine covers and tabloids and plots to influence the election, but what if you turn it around and argue that these kind of things in the media and deals and arrangements to influence elections, not only are they not crimes, he argued, they're actually something far more familiar. There's nothing wrong, he told the jury, with trying to influence an election. It's called democracy. Now, whether the jury sees all these deals as clear, intentional crimes or more like the spin and the scum that can exist at the margins of all kinds of political ploys to influence an election, that is the big question. Was it, in other words, politics as usual? This is what this case could boil down to. Past the receipts and a lot of the star witnesses, was this second thing clearly a campaign crime, or was it democracy?